Can the appellate division deny an application to reduce a sentence as unduly harsh or severe just because it was the product of a plea negotiation? To find out, you have to read People v. Ba, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals Cases in 5 minutes or less. This is the episode on People v. Ba. This can be found at 2023 New York Slip Opinion 01468. I include a copy of a link to that decision in the description. It's published by the Court of Appeals on March 21st, 2023. The same day the Court of Appeals decides another case that's similar fact pattern, similar issue, People v. Baldwin, which I'll review in another video. The issue in this case is what is the review standard of the appellate division in reviewing interest of justice reduction applications based upon the sentence being unduly harsh or severe. And I'll explain that in a second. The law you have to understand to appreciate this case is that the appellate division is the intermediate appellate court in New York. So there's a trial court, there's an appellate division, there's 4 of them, and then there's the Court of Appeals where there's one of. And that's what these TLDR videos are reviewing the Court of Appeals cases. But under CPL, Criminal Procedure Law 470.15, there's a variety of different powers the appellate division has to review lower court sentences and modify, reverse, or lower them, reduce them. Under CPL 470.15 4C, the appellate division has the authority as a matter of law to amend, modify, reduce, or reverse an illegal sentence, a sentence that's not authorized by the law. And under CPL 470.15 sub 6, they have the authority as a matter of discretion to reduce a sentence that is unduly harsh or severe. So those are 2 different authorities under CPL 470.15. So what happened in this case? In this case, the defendant was arrested, and prosecuted for selling counterfeit handbags on the streets of Manhattan. And he pleads guilty to a misdemeanor of unlicensed general vending. And that particular sentence has a sentencing range of $250 fine up to $1,000 fine, or jail of less than 3 months, or both, a fine and jail. The defendant is given a choice of either 3 days of community service or a $50 fine. The defendant takes the fine and then appeals. And he appeals on a couple of bases. First, he says that the sentence is harsh and unnecessary and likely to create a financial hardship for him. But then, while the appeal is pending, the DA's office decides as a policy matter they're not going to prosecute this particular crime anymore. So he puts that in the appeal as well, that it's not fair that he's being prosecuted for this. It's unduly harsh and severe because they're not prosecuting it anymore. And the appellate division, upon review of this application, says their response is that there is no basis for reducing the fine because the defendant got the precise sentence for which he bargained, which was within the statutory range. The defendant appeals that to the Court of Appeals, says wrong standard, and there's basically 2 concurring opinions. There's a concurrence basically to send it back to the appellate division for them to review it again and give a different answer. And Judge Garcia's concurrence says that Judge Garcia believes that the appellate division was not saying that they don't have the power to judge the sentence. They were just saying that it's not unduly harsh. But Judge Troutman's concurring decision, basically says that the appellate division erred in applying the wrong standard by saying that it's a bargain for disposition, that it was within the statutory framework. It's using the wrong section of CPL 470.15. If you remember, the 470.15 with regard to illegal sentence, that's a matter of law. But he wasn't making that argument. He was making as a matter of discretion, as being unduly harsh or severe. So Judge Troutman says the appellate division got it wrong by just referring to the illegality or legality of the sentence, that the appellate division has the power to modify an unduly harsh sentence completely separate and apart from whether the sentence is legal or not. Also, Judge Troutman notes that most criminal cases are resolved by plea, but the prosecutor and the defendant are not on equal footing. It's not equal bargaining power. And so a sentence may be unfair and unduly harsh, even though it's bargained for, because they're not equal bargaining partners. And finally, she notes that the power imbalance inherent in that positioning is that innocent defendants plead guilty, and sometimes guilty defendants serve disproportionate sentences. And there's racial disparities as a result as well. And finally, she notes that it's literally irrelevant whether the sentence was illegal with respect to this particular application as to whether it's unduly harsh. And that's the case of People versus Ba. Too long didn't read Court of Appeals cases in 5 minutes or less. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.